All right, in this video, we're going to go ahead and do a recap on the COPA v. Wright appeal and what's happening, if anything at all, and also just talk a little more detail about my own testimony in the case and what happened to set the record straight. So I posted a post here on X here. I said after failing to put Dr. Wright behind bars, UK biased Judge Mudd ruled on his own bias in the name of what just us. Team COPA then celebrated, and Satoshi remained free and pseudonymous. The U.S. legal system recognizes the origins of Bitcoin in clearly established law. And then I posted a picture there of Judge Mellors, Judge Mudd. It says I investigated myself and I found that I did nothing wrong. Then I got absolutely attacked by. I got attacked by people, COPA, pretty much. COPA, they have their reasons. They say that I'm a liar and a fraud. They did a bunch of name calling here. So you're lying again. And, the typical personal attacks. Now, let me just kind of comment on this and personally on why actually what I wrote here is 100% accurate. So it's not a lie. First of all, the U.S. law, clearly established law, has already determined the origins of Bitcoin. That is undeniable. It's well-settled law. It actually went to trial, and that was a jury trial in 2022. It was finally determined. And then at the end of 2023, the appeal was settled up in the 11th Circuit. That was Klieman's appeal. Klieman appealed the decision. And then the 11th Circuit decision, which is a tribunal over Florida and on basically all the circuit courts, all the district courts in Florida area in the southeastern part of the United States. They are the appellate. They are the 11th Circuit. These guys are the big, badass, federally appointed judges up there in the 11th Circuit. These guys are highly respected, federally, presidentially appointed, judges. And they came back and they said that they decided the origins of Bitcoin. All right. That was what was decided in the appeal after the trial. The trial and the appeal. The appeal basically settled it. The origins of Bitcoin are done. It's already decided. Okay, so that is well decided. And the origins are meaning that only Dr. Wright had all rights to all the original Satoshi coins, the 1.1 million coins or whatnot. There was actually 100,000 plus addresses that went into the case. Those are all Dr. Wright's and his companies. Nobody else, not Klieman, nobody else. There was a small fine that had to be paid well, first of all, when I say small, it was small in comparison to the actual ruling because the case was about some $60-odd billion, what the Klieman estate wanted when they sued Wright. So the small fine was something like, it was less than 1% of that, not even at 1%. It was like 1/10 of 1%. It was a small amount, a percentage that had to be paid as a sanction, basically, over to a company. And that company was 1/3 Klieman, 2/3 Wright-controlled. And that was basically the sanction. But it didn't, it wasn't, the decision was determined about the origins of Bitcoin that it was only Wright. All right, now, it didn't determine the identity of Satoshi Nakamoto. That wasn't determined. Any U.S. scholar who can read cases is clear as to it's presumed. I mean, it's settled in the U.S. Not technically the identity, but the origins are settled. Now, in the U.K., we had this decision with, we're calling him Judge Mudd now because he's completely gone way off the rails. I reported on the case, did all the trial every single day last year, 20-something trial videos, and it was fascinating. It was amazing. And what ended up happening in the trial was the Edgar, there's this Edgar Hansen effect. Now, Edgar Hansen was the CEO. He was the CEO of nChain at the time when the case was going on. And he was also in charge of the case for Dr. Wright. Now, if you get to know Dr. Wright a little bit more, and I really personally don't, I don't have a relationship with him, so I'm not saying from experience, from just kind of like watching at a distance and seeing how he operates. He kind of assumes, I think, that people are going to do things, like he works hard, and he assumes that people are going to do things. So it looks to me like he actually just kind of passed the ball over to Edgar Hansen when the case is going on and saying, get this done. get this case all ready for trial. All right. So Ager Hansen was in charge of it. He then hired some experts. Those experts were under Ager Hansen to respond to the Madden and the Rosenthal report. Turns out they didn't respond. They just agreed with what Madden and Rosenthal wrote. That right there lost the whole case for Dr. Wright. That was it. That case was over at that point. He cannot, no matter how bad the judge, whatever he had at trial, it didn't matter because the two experts agreed with Madden and Rosenthal. That means they got in. Without some sort of other expert, there was nothing for the judge to really decide on. Now, the expert from what's more recently come out is that inside of the ruling, there was a decision. There was another expert that was brought in by Dr. Wright, and it was ruled on by Mellor in one sentence in the appeal. This is in the appeal, and Joel had brought this up. Now, it was ruled on, but I haven't seen the report. I have not seen the expert's CV. I haven't seen his declaration and testimony at all. So that I have not seen. All I saw was some website. That website was not an expert report about, about looking at the case, personally. So hopefully there was an expert report with a CV and an affidavit, a declaration attached to it, saying the guy had personal knowledge and he reviewed these case files. I mean, if that was the case and that was ruled on, it definitely is super important. But from what I've seen, I have not seen it. All I saw was just a website with no testimony, no declaration, and nothing specific to the case that could have been used as evidence to support an expert opinion, unfortunately. That being said, the appeal then went to the Court of Appeal. The Court of Appeal rejected it. I was up at, what's his name? Judge Arnold. He rejected the appeal by Dr. Wright. And then after he rejected that appeal, then what happened then is that Wright was then called in for contempt at the same time. Now, the contempt scheduling hearing, they ordered Wright to appear in person. All right, so then the next day after the contempt scheduling hearing, that's when Arnold, the very next day, he rejected Wright's appeal. They were kind of waiting. They're saying, well, if the appeal is still going on, then, we might not have jurisdiction to take you in. There was just kind of some questions on whether or not they'd be able to arrest him. The next day, Arnold rejects the appeal. Now it's back in Mellors court. What happened was COPA, inside some of their briefings, they asked for Mellor to get dressed up in costume and COPA to get dressed up in costume. When they wear the costumes, they wear these wigs with the robes, and they look like it's like a circus clowns, in there. Literally, it's ridiculous. And they wear these costumes to what their point was in the writing from COPA that I read was to let Dr. Wright know, because Dr. Wright was not represented. So he had no representation. Let Dr. Wright know the seriousness of what he was facing and what he had done, and to cause maximum consequences for him. So they were going to sentence him at that. Well, they'd already sentenced him. Now they were going to put him in jail in custody at that hearing. Okay, that was their plan. They got all dressed up, and they were going to take him away in custody to then lock him down and, forced inoculate him most likely. And, we probably would never hear from him again, and they would make some excuse. So Dr. Wright saw this through. He left the country, went off to some unknown place in Asia. He just flat out didn't show up at the hearing. This is absolutely unprecedented. It wasn't like him at all. From what I've seen, his behavior, he, not showing up at court was not like him. But they refused to let him appear on the phone at this hearing. So he wasn't allowed to do that. He had to be there in person. He kind of objected at the scheduling hearing that he would show up. He just flat out didn't show up. COPA was very upset about that. They went forward anyways, and they got their sentencing. They then agreed to let him appear by phone the next day. So he appeared by phone the next day just to hear what the ruling was. The judge then found that the next day is when we got to hear more about what happened. Now, here's where things got interesting, because the next day, Judge Mellor rules on his own bias and disqualification. Yeah, about 2 weeks earlier, I had actually done it was probably a month or earlier or so. Basically a bunch of people 700 and something people online, 700 people plus, signed a petition to have this case investigated. They believe there was just corruption, bias. It was a sloppy case because Tufty the Cat, the attorney David Pierce, he had went on my show and he had been talking to the judge ex parte, meaning like just him and the judge. And it was before the case, and then it was during the case, and then it was, after the case ruled on. They also discussed one of the parties in the case, Adam Back, who's a member of COPA, and he testified. Anyways, it was really sloppy. It was getting really ugly. So I was like, let me go ahead and do a full analysis of all this information, legal analysis, and give my opinion. So I wrote up an affidavit. The affidavit is it is what was called admissible. I know how to write an affidavit in accordance with the federal rules of procedure, which is going to be a specific rule. I could find it, and just so you know. Yeah, 22 CFR 92.22, 23, 24, 25, 26, 27 for the substance is 92.27. That's 22 CFR 92.27. So anyways, it has to be in a very specific technical format to be admissible in a court of law. And the federal rules there do the best job on applying that. So the affidavit that I wrote was right in line with that, like to a T. So when the judge got it, Judge Mudd, he got that because Craig Wright, what he did was he filed a motion to disqualify that judge. That was a couple weeks before, after his contempt scheduling hearing. And in that motion was my affidavit that I did a full analysis of everything that I saw from personal knowledge of interviewing Mr. Pierce and watching the court case every day, and the petition getting removed from the internet by what I believe to be Jack Dorsey of COPA as a founding member over there and a decision maker over there at change.org. All that was in there. And then so the court then ruled, he got it, and you notice that the judge made, I think it was a he wrote 2-page decision about this affidavit. He took it very seriously. Very seriously. You know how, it's what a judge will do when they don't look at something, they'll just put denied, one word, denied, and they'll throw it out because it's just nonsense or frivolous or it doesn't matter. They don't even want to look at it. But when it's right in line with exactly what he has to do, and it's gonna be a major issue of a fact, he will make a very detailed opinion about it. And he made 2 pages, and one fact that the judge ruled on, which what's called a triable issue of fact, was he said the judge says, I did not go to any COPA event. I didn't go to any KIPA events. I didn't go to any COPA/KIPA events. Period. I did not go to anything like any of that. That was a triable issue of fact that had to be brought over to another judge. Okay? Now, not every issue in the affidavit was triable that the judge ruled on, but that one was, because the judge made a what's called an admission or a denial. He denied the fact of going to a COPA event. Did he go to a COPA event? Was there a COPA event? Was KIPA a COPA event? This has to be investigated because the judge says he didn't go to one, but he went to some event, but apparently it wasn't a KIPA event. Anyways, this was the fact that had to be investigated by another judge. They had to look at that and look at these events and see, well, what were these events the judge had went to? Because he went to these events, he met with the attorney, and they talked about the case. What was that event all about? Who was behind that event? That had to have been looked at by another judge. It wasn't. Judge Mudd, Judge Miller, we're calling him Judge Mudd because of what he did here. He says, well, I didn't go to any COPA event, and I can rule on that myself because I am in the just us system. So for the people saying, oh, he quit bringing up just us system. No, this is exactly what went on. You have the just us system. Mellors ruling on himself, when that's a perfect example of just us. If you're not in it, sorry, you're out. So Mellor ruled on him on his own decision, on his own bias, saying that he never went to a COPA event, never went to a KIPA event, never went to those events. But we know that he did go to an event. We saw that. We saw that his picture was taken with Tufty at the event. So now it's like, well, what event was that? What was it? A COPA event? No, it wasn't. Oh, was it? Well, what type of event was that, Judge? I don't want to talk about that. Okay, well, that's what I had to go to another judge. Another judge can look at it and seeing, well, what were you doing at this event, Judge? You were there with Mr. Pierce, and you guys were talking about the court case. That's on the record. We know that he talked about the court case, Mr. Pierce. There's photos of him at the event. So there's lots of photos, there's videos of him at a event, at multiple events. So that became a triable issue of fact from that affidavit. The judge just threw it out he didn't throw it out. He just didn't, he didn't throw it out. He actually ruled on it. His ruling on it made it improper and a completely biased decision at that point. Now, the merits of the Satoshi trial and the identity issue are done. Apparently, Dr. Wright went to the Supreme Court on it. I don't know. If he did, great. I think I just don't see how he's going to get there, but he has been to the Supreme Court before. I think there's some other interesting information that's coming out now that a unnamed party who I know, his uncle, is on the Supreme Court. Apparently. I don't know the guy, but I know somebody who his uncle is on the Supreme Court. Well, maybe they should sue, all of us because we know somebody at the Supreme Court. I'm saying, no, it doesn't matter. Either way, I talked to the guy, and it's not like he's not communicating with his uncle. It's just he has no communication with him at this time. But he did say that his uncle knows the difference in Bitcoin and what the white paper says, what BTC is, what BSV is, and what the original Bitcoin. He said he knows the difference in that. He's very competent in Bitcoin. So that'll be interesting if it goes up to the Supreme Court. That really isn't an issue in this case, but it'll be interesting if it does. Wright did go to the Supreme Court before on the what's called the McCormick case, and then they rejected the appeal up there. So I still don't see how he's going to go to the Supreme Court because the local rules don't support going there. When they reject the case at the appellate level, he's not allowed to go to the Supreme Court. The only issue that I'm seeing left is Mellors' disqualification, Mellors' bias, because Mellor just ruled on his own fact, saying that he didn't go to any COPA event. He ruled on that. It didn't go to another judge. That's a major issue. That should have been ruled on. That right there, not the identity issue of Satoshi Nakamoto, but Mellor himself. Mellor's own disqualification in this case, that needs to be heard on appeal first, and then that could be heard at the Supreme Court. And I don't know if Wright knows that or not, but or whether or not what his strategy is. It's kind of a secret right now what his strategy is. I'm not his attorney. I'm not an attorney. I'm a freaking guy out here in California, who's an armchair quarterback in this case and testified as a witness. That's it. But I do know the strategies and the procedures here. So, anyways, my point is that if there's an appealable issue, it's the disqualification of Mellor. What would the result be, though, if Mellor was disqualified? It'd be the same result, man, of overturning the whole case. The whole case would have to go back. Mistrial, bad ruling, improper judge. Same effect. So, this is going to sound like freaking some sort of a cope or copium or hopium bullshit. But, I'm really not presenting this video with that intent. I'm just like letting you know I want to let people know the history of what actually happened here so that we can set the record straight for these COPA people who are rooting COPA on, and they just want, they want to have their own, they don't want to have the actual facts, and they want to say what I'm saying is not true and it's a lie. And that's not, what I wrote in that post on X is 100% what happened. They ruled on the Satoshi. I'll recap it again. After failing to put Craig Wright behind bars, the UK biased judge Mudd ruled on his own bias. In the name of justice, Team COPA celebrated and Satoshi remained free and pseudonymous because we never got to define the identity of Satoshi Nakamoto in the law. He remained pseudonymous and free. But the U.S. legal industry recognizes the origins of Bitcoin as clearly established law. That is well defined. The origins of Bitcoin. Different issue, the origins versus the identity. So, if you like this video, hit the ones. A little recap on what actually happened in my testimony in the case. Once I hear some more on the Supreme Court, anything else, I'll be sure to report on it. if there's anything else happening, I'll see you at the freaking top. Gavin Mayo.